Welcome everyone. In this presentation, I would like to talk about client due diligence. In 1990, Financial Action Task Force, shortly known as FATF, introduced 40 plus 8 special recommendations, which are now 9, as a complete set of countermeasures against money laundering and terrorist financing. Together, the 40 recommendations and the special recommendations on terrorist financing set the international standard for anti-money laundering measures and in combating the financing of terrorism and terrorist acts. They set out the principles for action and allow countries a measure of flexibility in implementing these principles according to their particular circumstances and their constitutional frameworks. Both sets of FATF recommendations intends to be implemented at the national level through legislation and other legally binding measures. Among these recommendations is to implement customer due diligence for financial institutions and designated non-financial businesses and professions. As per the FATF's recommendation number 5, financial institutions and other designated non-financial businesses should not keep anonymous accounts or accounts in obviously fictitious names. Institutions should undertake customer due diligence measures, including identifying and verifying the identity of their customers. Customer due diligence measures ensures that businesses know who their clients are so that they do not accept clients whose business they do not fully understand. Identification and verification of identity procedures should be completed before entering into a business relationship. This also applies to occasional transactions. We will look into identification and verification process in detail later in following slides. In this presentation, we will look at the customer, that is client due diligence, shortly known as CDD, from the financial institution's point of view. CDD refers to identifying the customer and verifying that customer's identity using reliable, independent source documents, data, or information. Identifying the beneficial owner and taking reasonable measures to verify the identity of the beneficial owner such that the financial institution is satisfied that it knows who the beneficial owner is. For legal persons and arrangements, they should include financial institutions taking reasonable measures to understand the ownership and control structure of the customer. Obtaining information on the purpose and intended nature of the business relationship. Financial institutions should apply each of the CDD measures stated above, but may determine the extent of such measures on a risk-sensitive basis, depending on the type of customer, business relationship, or transaction. The measures that are taken should be consistent with any guidelines issued by competent authorities. To note that where the financial institution is unable to comply with the above stated requirements, it should not open the account, commence business relation, or perform transaction, and should terminate the business relationship. Also should consider making a suspicious transactions report in relation to that customer. Countries may permit financial institutions to complete verification in some cases as soon as reasonably practicable following the establishment of the relationship, where the money laundering risks are effectively managed and where this is essential not to interrupt the normal conduct of a business. We will come back to this section later. Conducting ongoing due diligence on the business relationship and scrutiny of transactions undertaken throughout the course of that relationship to ensure that the transactions being conducted are consistent with the institution's knowledge of the customer, their business, and risk profile, including, where necessary, the source of the funds. Also to note, this requirement should apply to all new customers, though financial institutions should also apply these recommendations to the existing customers on the basis of materiality and risk, and should conduct CDD on such existing relationships at appropriate times. Identification refers to the basic information you need to obtain and record about your clients to know who they are. For example, for an individual client, you would generally collect legal name and any other names used, such as maiden name, correct permanent address, The full address should be obtained. PO box number by itself is not sufficient. Nationality, occupation, public positions held, and or the name of employer. To note here that the occupation does not need to be employment. If your client is a retired, a homemaker, a volunteer caregiver, or otherwise occupied, you should record that information. You need to collect telephone number, fax number, and email address, date and place of birth, an official personal identification number, or other unique identifier contained in an unexpired official document such as passport, identification card, residence permit, social security records, driving license, etc., that bears a photograph of the customer. You need to have the type of account, the nature of the banking relationship, and signature. The examples quoted above are not the only possibilities. In particular jurisdictions, there may be other documents of an equivalent nature that may be produced as satisfactory evidence of customer's identification. In considering the customer identification guidance for the different types of institutions, particular attention should be given to the different levels of risk involved. Next step is verification of the information provided. Verification refers to the information you need to obtain to confirm that your client is who or what they say they are. This is done by review of independent and reliable original source identification documents such as government-issued driver's license, birth certificate, or passport. The financial institute should verify the above information by at least one of the following methods. For established corporate entities, reviewing a copy of latest report and accounts audited if available, conducting an inquiry by a business information service, or an undertaking from a reputable and known firms of lawyers or accountants confirming the documents submitted. Undertaking a company search and other commercial inquiries to see that the institution has not been or is not in the process of being dissolved, struck off, wound up, or terminated. By utilizing an independent information verification process, such as by accessing public and private databases, obtaining prior bank references, visiting the corporate entity where practicable, contacting the corporate entity by telephone, mail, or email. Also to note that the organization should take reasonable steps to verify the identity and reputation of any agent that opens an account on behalf of a corporate customer, if that agent is not an officer of the corporate customer. For corporations' partnerships, the principal guidance is to look behind the institution to identify those who have control over the business and the company's or partnership's assets, including those who have ultimate control. For corporations, particular attention should be paid to shareholders, signatories, and others who inject a significant proportion of capital or financial support or otherwise exercise control. Where the owner is another corporate entity or trust, the objective here is to undertake reasonable measures to look behind that company or entity and to verify the identity of the principals. What constitutes control for this purpose will depend on the nature of a company and may rest in those who are mandated to manage funds, accounts, or investments without requiring further authorization and who would be in a position to override internal procedures and control mechanisms. For partnerships, each partner should be identified, and it is also important to identify immediate family members that may have ownership control. Identify the customer and verify its identity. The types of measures that would be normally needed to satisfactorily perform this function would require obtaining proof of incorporation or similar evidence of legal status of the legal person or arrangement. Where an occupational pension program, employee benefit trust, or share option plan is an applicant for an account, the trustee and any other person who has control over the relationship, example administrator, program manager, and account signatories, should be considered as principals, and the financial institution should take steps to verify their identities. Where cooperatives and provident societies are applicant of an account, the principals should be identified and should be considered to be those persons exercising control or significant influence over the organizational assets. This will often include board members plus executives and account signatories. In the case of accounts to be opened for charities, clubs, and societies, the financial institution should take reasonable steps to identify and verify at least two signatories along with the institution itself. The principals who should be identified should be considered to be those persons exercising control or significant influence over the organization's assets. This will often include members of a governing body or committee, the president, any board members, treasurer, and all signatories. As charitable organizations are most vulnerable to terrorist financing, registered charity number, copy of the charity's constitution are generally required as identification documents. When opening an account for a trust, the financial institution should take reasonable steps to verify the trustees, the settlers of the trust, including any persons settling assets in the trust, any protectors, beneficiaries, and signatories. Beneficiaries should be identified when they are defined. In the case of a foundation, steps should be taken to verify the founder, the managers, directors, and the beneficiaries and the purpose of that trust. Information collected, such as name of the account, mailing address, contact phone number, fax numbers, some form of official identification number, if available a tax identification number, description, purpose, activities of the account holder in a formal constitution, copy of the documents confirming the legal existence of the account holder. All should be verified by obtaining an independent undertaking from a reputable and known firms of lawyers or accountants, confirming the documents submitted, obtaining prior bank references, accessing public and private databases or official sources. Financial Action Task Force Recommendation Number 5 specifies the guideline on when and how to apply CDD. It is up to the businesses to determine the extent of CDD measures on a risk-sensitive basis, depending on the type of customer, business relationship, product, or transaction. They should be able to demonstrate to the supervisory authority that the extent of CDD measure is appropriate in the view of risk of money laundering and terrorist financing. Again, the emphasis is on the consideration of risk in relation to the client and the business carried out for them, and need to keep matters under ongoing review throughout the relationship. This allows firms to move away from a tick box, one-size-fits-all regime and operate a system that is proportionate to the perceived risk and more flexible. While this offers benefits, it may also pose challenges in the term of managing compliance. Also to note that where the financial institution is unable to obtain enough and satisfactory information, it should not open the account or commence business relationship or perform transactions, should terminate the business relation, should consider making suspicious transaction report in relation to the customer as mentioned earlier. Consideration of risk is paramount in deciding whether you may proceed beyond initial contact before verifying identity. Based on risk, there are circumstances where it would be permissible for verification to be completed after the establishment of business relationship, because it would be essential not to interrupt the normal conduct of business. This also confirms that the identity of beneficial owner needs to be established in order that identity may be verified at the earliest possible stage and before any transaction is undertaken. A beneficial owner to define is a person purporting to act on behalf of a customer and is so authorized. It is a requirement to identify the beneficial owner and take reasonable measures to verify the identity of beneficial owner such that the financial institution is satisfied that it knows who the beneficial owner is. For legal persons and arrangements, this should include financial institutions taking reasonable measures to understand the ownership and